The Department of Justice just declared a federal gun law unconstitutional, not a state regulation, not some obscure county ordinance, a federal statute that's been on the books since 1927. The DOJ, the same agency that's supposed to defend federal laws in court, just told the country that this particular gun control law violates the Second Amendment and should no longer be enforced. This almost never happens in American law. Federal agencies defend their statutes, they fight for them, they argue creative interpretations to keep them alive. But here we are in 2026, and the Department of Justice has formally declared that the federal ban on mailing handguns is unconstitutional and lacks any historical analog consistent with America's constitutional tradition. If you carry a firearm, if you train with one, if you travel across state lines, if you even maintain guns as part of your daily life, this development matters to you in ways you haven't yet considered. And if you live in New Jersey or any state that's built its entire gun control regime on friction, delays, and bureaucratic exhaustion, this should absolutely be screaming on your radar right now. Before I show you exactly why this changes everything and where the legal earthquake is heading next, I need you to do something. Subscribe to this channel immediately, hit that like button, and drop a comment telling me what state you're in and whether you've experienced the kind of regulatory nightmares I'm about to expose. Because this is information the mainstream media will never explain to you, and your rights depend on understanding what just happened. The DOJ's Office of Legal Counsel issued a formal memorandum that does something extraordinary in the world of federal law enforcement and constitutional litigation. It concludes that the federal law banning the mailing of handguns violates the Second Amendment. Not that it's outdated, not that it needs reform, that it is unconstitutional and cannot be defended under the framework the Supreme Court established in the Bruin decision back in June 2022. This isn't advocacy from some gun rights organization. This isn't a lawsuit filed by activists. This is the federal government itself saying this law cannot survive constitutional scrutiny. The statute in question dates all the way back to 1927, a completely different era in American jurisprudence when the Second Amendment was barely recognized as an individual right, long before the Supreme Court's landmark decision in D.C. versus Heller in 2008 that affirmed the individual right to keep and bear arms, and decades before the modern reality of interstate travel and commerce that defines how Americans actually live their lives today. The law was passed in an era when people traveled by train and horse-drawn carriage was still within living memory, and it survived for nearly a century simply because nobody seriously challenged it under modern constitutional standards until recently. This is not routine legal business. The Department of Justice almost never declares its own federal statutes unconstitutional. Think about what that means. The DOJ's entire institutional purpose includes defending federal laws when they're challenged in court. That's their job. They're supposed to find ways to uphold statutes, to argue for narrow interpretations that save them, to present historical evidence that supports the government's position. Historically, when the DOJ has doubts about a law's constitutionality, they either defend it anyway and let the courts decide, or they quietly stop enforcing it without making any public announcement or formal declaration. But this memorandum does something completely different. It explicitly applies the Bruin framework, the text history and tradition test that the Supreme Court established for evaluating gun laws. And it concludes plainly that this federal handgun mailing ban fails that test. There is no historical analog. There is no tradition of preventing Americans from mailing firearms to themselves or to others through common carriers. The government looked for historical support and couldn't find it, so they're conceding the constitutional ground. And that concession is a massive signal, not just to lower federal courts that might hear challenges to other gun laws, but specifically to states like New Jersey, New York, California, and others that have built their entire regulatory approach on creating layers of restrictions, mountains of friction, and procedural exhaustion designed specifically to suppress lawful gun ownership even when they can't ban it outright. But here's why the DOJ's reasoning in this memo matters even more than the immediate outcome of no longer enforcing the handgun mailing ban. The legal logic they used doesn't stop with this one statute. The memorandum explains something that should fundamentally reshape how we think about gun rights in America. It says the Second Amendment doesn't just protect the narrow act of possession or the narrow act of carrying a firearm in public. The Second Amendment necessarily protects what the memo calls ancillary rights, the related activities that are required to actually exercise the core constitutional right. This includes the right to acquire firearms in the first place. You can't exercise your Second Amendment rights if you can't legally obtain a gun. It includes the right to transport firearms from one place to another. Your right to bear arms is meaningless if you can't move your gun from your home to the range or from one state to another when you relocate. It includes the right to train with your firearms. The Second Amendment would be hollow if the government could prevent you from ever practicing or becoming proficient with the arms you're constitutionally entitled to keep and bear. And it includes the right to maintain and repair your firearms. A right to keep arms that you can't maintain or fix when they break is not a real right at all. The memo states this principle plainly, and I want you to hear these exact words because they're devastating to the entire regulatory infrastructure that gun control states have built over decades. The right would be meaningless if the government could prevent citizens from ever receiving such arms. That single sentence should make state legislators in places like New Jersey and New York extremely nervous, because that's exactly what their regulatory schemes are designed to do. They don't ban guns outright because they know that would be struck down immediately. Instead, they make receiving guns difficult, expensive, time-consuming, and legally risky. They make transporting guns a maze of restrictions where one wrong turn makes you a felon. They make training expensive and inaccessible by limiting where ranges can operate. They make maintenance and repair difficult by restricting gunsmiths and parts. And now the Federal Department of Justice has put in writing that those tactics violate the constitutional principle that ancillary rights necessary to exercise a core right are themselves constitutionally protected. This isn't some fringe legal theory. This is now the official position of the United States Department of Justice under the current administration here in 2026. The DOJ didn't speak in abstract legal theory when they issued this memorandum. They spoke in concrete reality, giving specific examples that many gun owners already understand from painful personal experience. The memo addresses real-world scenarios where the federal handgun mailing ban created impossible situations for lawful gun owners trying to exercise their rights. Consider this scenario that the DOJ specifically cited. You need to fly through hostile states like New York or New Jersey or California, states with regulatory schemes so complex and punitive that even trying to comply in good faith can land you in criminal jeopardy. Federal law is supposed to protect you during interstate transport under the Firearm Owners Protection Act, but those protections can be lost during something as simple as an overnight stop. If your flight gets canceled and you're forced to stay in New York overnight with your checked firearm, you might suddenly find yourself in violation of state law even though you were just trying to travel peacefully through the state. Airlines, buses, trains, and other common carriers often deny firearm transport entirely or impose such burdensome requirements that it becomes practically impossible. In those situations, being able to mail your handgun to yourself at your destination or to an FFL dealer at your destination might be the only lawful option that doesn't involve hiring a specialized transport service at enormous cost or simply giving up your constitutional right to travel with the means of self-defense. And this is exactly how rights get functionally erased in America. Not through dramatic bans that make headlines and spark protests, not through legislation that says you cannot own guns, but through logistics, through administrative burden, through making the exercise of a right so difficult, so expensive, so legally risky, and so procedurally complex that ordinary people simply give up rather than navigate the maze. If you can't afford the time and money to jump through all the hoops, you effectively don't have the right, even though it technically still exists on paper. If you can't figure out the constantly changing patchwork of state laws and carry restrictions and sensitive place designations, you effectively can't exercise your carry rights, even though you theoretically have a permit. If you can't transport your firearm from point A to point B without risking felony prosecution for an inadvertent violation of some obscure regulation you didn't even know existed, then your right to keep and bear arms has been functionally nullified. The DOJ memo recognizes this reality explicitly. It acknowledges that banning the mailing of handguns, combined with other transport restrictions and carrier policies, can make it literally impossible for a law-abiding citizen to receive or transport a firearm in certain situations. And when the government makes it impossible to exercise a constitutional right, that's a constitutional violation, regardless of whether they're calling it a ban or just calling it a regulation. If you live in New Jersey, and I know many of you watching this do, you need to pay extremely close attention to what's happening here because New Jersey's entire gun control model is friction-based control. It's not primarily about outright bans anymore, though New Jersey has plenty of those too. It's about making every single step of lawful gun ownership as difficult and burdensome as possible. Start with permit delays. Getting a permit to purchase a handgun in New Jersey can take weeks or months depending on your local police department's processing speed and willingness to prioritize your application. There are people who've told me directly that they waited 6 months just to get approval to buy a single handgun. Then there are transport traps, and we've covered this extensively before. New Jersey's unreasonable deviation clause in its transport law that can turn illegal transport into a felony if a police officer decides your stop for gas or food or a bathroom break was unreasonable. The law is vague enough that you're at the mercy of prosecutorial discretion, which means you're not really protected at all. There are administrative choke points throughout the system, extended permit timelines that have no justification other than making you wait, layered approvals required for completely ordinary activities like buying ammunition or taking your gun to a different range, discretion disguised as objective procedure where officials claim they're just following the rules, but somehow those rules always seem to result in denials or delays. New Jersey also uses cost and time as deterrence weapons. Many gun owners have told me they simply cannot afford to get their carry permit in New Jersey because of the training requirements, the application fees, the time investment required, and the risk that they'll be denied anyway after spending hundreds or thousands of dollars. The system is designed to make you think twice about whether exercising your constitutional right is worth the hassle and expense. Then there are the forced intermediaries that New Jersey mandates for routine actions. You want to transfer a handgun to a friend? You can't do it directly, even though you're both law-abiding New Jersey residents. You have to go through a federal firearms licensee, pay their transfer fee, and your friend has to have a valid permit to purchase. There's no direct path for lawful gun owners to deal with each other the way you could with any other legal property. Every transaction has to go through a middleman that the state approved, and if that middleman makes an error on the paperwork, you could face criminal liability for their mistake. There are also limited availability bottlenecks that can shut down your ability to exercise your rights through no fault of your own. What happens when the nearest FFL closes or relocates, and now you have to drive an hour each way to handle a basic transfer? What happens when the local police department that processes permits is short-staffed and simply isn't processing applications for months at a time? This matters because a right that you can only exercise at the convenience of government-approved intermediaries on the government's timeline, subject to the government's administrative capacity and willingness to process your paperwork, is not fully a right at all. It's a privilege that can be granted or withheld based on bureaucratic whim, and this DOJ memorandum directly undermines that entire approach. When the federal government says in an official legal memorandum that you have a constitutional right not just to possess firearms, but to receive them, to transport them, to train with them, and to maintain them, and that the government cannot impose restrictions that make those ancillary rights impossible to exercise, that legal reasoning doesn't stop at the New Jersey state line. It applies everywhere. It applies to every restriction that makes the exercise of Second Amendment rights practically impossible, even when it's theoretically legal. And if you think this is just about mailing handguns and doesn't affect you because you never planned to mail a gun anyway, you're missing the bigger picture entirely. The principle established in this memo, that ancillary rights necessary to exercise a core constitutional right are themselves protected, is going to show up in courtrooms across New Jersey and across the country in cases that have nothing to do with mailing firearms. Expect this DOJ memorandum to be cited extensively in New Jersey permit litigation. When gun rights organizations challenge the state's carry permit delays and denials, they're going to point to this memo and argue that New Jersey's system makes it practically impossible to exercise the right to bear arms in public that the Supreme Court recognized in Bruin. The DOJ has now agreed that making a right practically impossible to exercise is a constitutional violation. Expect this memo to appear in challenges to New Jersey's transport laws and the unreasonable deviation standard that creates felony exposure for normal travel. The DOJ said you have a constitutional right to transport firearms, and restrictions that make transport legally risky violate that right. Expect this memo to be used in attacks on New Jersey's FFL bottlenecks and mandatory intermediary requirements. The DOJ said you have a constitutional right to receive and acquire firearms, and forcing you to go through intermediaries who might not be available or who might make errors is a burden on that right. Expect this memo to show up in challenges to laws that make gun ownership theoretically legal but practically impossible through a combination of cost, delay, complexity, and legal risk. That's exactly the kind of friction-based control that this DOJ memo says is constitutionally problematic. And if you're getting value from this breakdown, if you're starting to understand how a single DOJ memo can reshape the legal battlefield across the entire country, then you need to subscribe to this channel right now, turn on notifications so you don't miss the next update when courts start actually ruling on these issues, and leave a comment telling me what aspect of your state's gun laws you think is most vulnerable to challenge under this new DOJ position, because I'm building a community of gun owners who understand that knowledge is the first line of defense against unconstitutional restrictions. This is not the end of the fight. This is really just a starting point. Courts move slowly, as anyone who's followed Second Amendment litigation knows painfully well. Cases take years to work their way through the system. Appeals happen, injunctions get issued, and then stayed. The legal process is designed for deliberation, not speed. But cultural and political shifts don't move slowly. They can happen fast. And when the Department of Justice, the chief federal law enforcement agency in the country, formally concedes constitutional ground on a gun control statute, that changes the litigation terrain nationwide immediately. It changes what arguments are viable. It changes what positions are defensible. It changes the confidence level that states have in their own restrictions. States like New Jersey that built their entire gun control infrastructure on inertia, on legal ambiguity, on exhausting gun owners through process, and on the assumption that the federal government would always back up restrictive interpretations, are now standing on much thinner ice than they were a year ago or 2 years ago. The ground is shifting underneath them, and they know it. This isn't about celebration or declaring victory. Gun rights advocates who've been through enough legal battles know better than to spike the football prematurely. This is about awareness. This is about understanding what just changed and what it means for the battles ahead. Constitutional rights don't disappear all at once in a single dramatic moment. They erode quietly, one restriction at a time, one regulation at a time, one administrative burden at a time, until what was once a clear right becomes so hedged with conditions and requirements that it barely resembles a right anymore. That's how rights die in America. Not with a bang, but with a whimper. Not through repeal, but through regulation. But rights can also be restored the same way. One successful court case at a time, one overturned restriction at a time, one agency concession at a time, one DOJ memo that changes the legal framework that all the other battles are fought within. This memorandum declaring the federal handgun mailing ban unconstitutional doesn't erase New Jersey's permit delays overnight. It doesn't automatically strike down the transport restrictions or eliminate the FFL bottlenecks, but it weakens the legal and logical foundation that those restrictions are built on. It establishes principles that can be used to attack them. It shifts the burden in ways that make defensive litigation harder for the states and offensive litigation easier for gun rights organizations. But before you go anywhere, before you change how you operate, there is one critically important reminder that you absolutely must understand. This DOJ memorandum does not change New Jersey law today. Right now, as of this moment in early 2026, New Jersey's permit requirements are still in force. The transport rules are still in effect. The FFL requirements for transfers are still mandatory. This is not a green light to start mailing handguns or to alter how you buy firearms or transport them or ship them to other people. The DOJ saying a federal law is unconstitutional and should not be enforced does not automatically mean that state laws on the same topic are void. States can have their own laws. States can have restrictions that go beyond federal law. And until a court specifically strikes down a New Jersey statute or regulation, or until the New Jersey legislature repeals it, you are still bound by it. Violating New Jersey gun laws because you read that the DOJ thinks a related federal law is unconstitutional would be an incredibly foolish way to become a test case and potentially a convicted felon. What this DOJ memo does change, in my assessment, and in the assessment of people who litigate these cases professionally, is the legal landscape going forward. It changes what arguments are available. It changes how courts are likely to view restrictions that make the exercise of Second Amendment rights practically impossible through administrative burden. It changes the confidence level that gun control states can have in defending their friction-based regulatory schemes. It makes litigation more viable and more likely to succeed. It creates momentum in a direction that favors constitutional rights over regulatory control. But that process takes time. Courts will need to issue rulings. Appeals will need to be resolved. Injunctions will need to be sought and granted. The legal system will grind forward at its typical glacial pace. For now, in the immediate reality of your daily life as a gun owner in New Jersey or any other restrictive state, the rules have not changed. You still need to follow the law as it currently exists. Stay compliant with every permit requirement, no matter how burdensome. Follow every transport restriction, no matter how absurd. Use the required FFL intermediaries, no matter how inconvenient. Document everything. Keep receipts. Know the laws that apply to you. And most importantly, do not test boundaries or push limits based on what you think should be legal or what a DOJ memo said about a different law. That is not how you protect your rights. That is how you lose your freedom and become a cautionary tale. What you should do instead is stay informed about developments as they happen. Watch for court challenges that cite this DOJ memo. Pay attention when gun rights organizations file lawsuits attacking New Jersey's regulatory schemes. Track the progress of those cases as they move through the courts. Understand that change is coming, but it's coming through the legal process, not through individual acts of civil disobedience that will land you in prison. Support organizations that are doing this litigation work if you believe in the cause. Make your voice heard in the political process. Vote for candidates who respect constitutional rights. Contact your legislators when gun control bills are being considered. Build community with other gun owners who understand what's at stake. But do not, under any circumstances, assume that a DOJ memo about federal law changes what you're required to do under state law today. I will continue to cover updates as things actually change in court. When an injunction gets issued, when a law gets struck down, when a regulatory scheme gets invalidated, When something happens that actually changes your legal obligations and your legal risks, I will break it down for you in plain language so you know exactly what it means and what you should do about it. And that's exactly why you need to subscribe to this channel if you haven't already. Hit that subscribe button right now, turn on the notification bell, share this video with every gun owner you know in New Jersey and every other state that treats the Second Amendment like a privilege that can be granted or revoked at government discretion. Leave a comment telling me what you want me to cover next as these legal battles continue to develop throughout 2026 and beyond. The mainstream media will not explain this to you. Gun control advocates will not acknowledge what this means. Your local politicians will not admit that their entire regulatory scheme just got undermined by the Federal Department of Justice. But I will keep tracking it. I will keep explaining it. I will keep giving you the information you need to understand your rights and protect your freedom. Because gun owners deserve better than being kept in the dark about legal developments that directly affect their lives. You deserve to know when the ground is shifting. You deserve to understand what tools are being built that can be used to fight back against unconstitutional restrictions. And you deserve honest information about what has changed and what hasn't, what you can do and what you absolutely should not do. That's what this channel provides. That's why you're here. And that's why you need to stay connected as this story continues to develop in the months and years ahead.